Further to my left is Assistant City Attorney Janice Dean, Legal Counsel to the Board, and Donna Brown, Human Resources Director. And I apologize, what's your last name?
Asmus.
I'm sorry?
Asmus.
Asmus. And there are other people from your staff here, sir?
Yes, to my left is Jim Parks. He will be communicating with me during the proceedings, and to my right, mostly manning the video equipment, is O'Reilly Ryan.
I'm going to ask, are these microphones just for the recording, or are they also transmitting or amplifying what's said throughout the room? Just for the recording. Okay, so it doesn't amplify anything. I'm just going to have to ask you to speak up a bit.
Okay, I'm sorry.
And we'll go through some of the rules due to COVID, and one of those will be that you can remove your mask. Also, for those I'm going to ask the respondent party, the City Department, to introduce themselves and members of the respondent's party.
Good morning, Mr. Chair. My name is Diana Day with the City Attorney's Office. To my right is Bill Hyland, also with the City Attorney's Office. And to my left is Scottsdale Police Department Chief Alan Rockbell.
Thank you. By authority of the City of Scottsdale's Charter and provisions of Chapter 14 of the Scottsdale Revised Code relating to human resources management, the board is appointed and empowered to hear and act on the appeals of regular employees of the classified service from a suspension, demotion, or dismissal by the City Department. The City Code authorizes and directs the board to hear and weigh all facts to be appealed and make a recommendation to the city manager that the actions of the department be upheld, overruled, or modified. The city manager is subsequently required to review the findings and recommendations of the board and determine the final action in each case. The city code authorizes the board to examine witnesses under oath or affirmation. Each member of the board has the power to administer the oath or affirmation as applicable to witnesses. In addition, I, Stephen Patel, as chairperson of the board, has the power to rule on the relevance of all evidence and testimony, limit or exclude lines of questioning and testimony that may be irrelevant, immaterial, or unnecessarily repetitious, rule on objections to testimony or examination of evidence, control how the hearing is conducted, and take any other action necessary for a complete and fair hearing. The following rules of order shall apply during this hearing. The hearing shall be conducted in accordance with the Arizona Open Meeting Law. Technical rules of evidence applicable to state and federal rules shall not apply. All testimony, however, shall be upon oath or affirmation. Upon the request of either party may exclude any or all witnesses not approved just in a few moments. Exclude witnesses from hearing the testimony of other witnesses. Neither the appellant nor the respondent or their attorneys, however, shall be excluded from the hearing at any time. Each party shall have the right to call and examine and cross-examine witnesses and to introduce documentary evidence into the record. Each party has the right to register an objection to the admission or rejection of evidence and to the extent of the limitation of any examination or cross-examination. Each party shall have the right to make a revoking statement before the respondent begins to present evidence. The respondent, the City of Scottsdale, Chief of Police, shall be called first to present evidence, to call witnesses in support of its charges. The appellant shall be given the option to cross-examine. After the appellant has completed cross-examination, the board shall be given the opportunity to ask the witness questions. The appellant Aaron Minor shall be called second to present evidence and call witnesses in support of his charges. The respondent shall be given an opportunity to cross-examine. After the respondent has completed their cross-examination, the board shall be given the opportunity to ask the witnesses questions. After all the evidence has been presented, each party shall be allowed to give a summation of their position, beginning with the respondent. Following summations, the board will determine in open session its findings of fact, conclusions, and recommendations related to the discipline imposed upon the appellant's chief. A member of the board chosen by the chairperson shall report the findings of fact and conclusions. The findings of fact and conclusions shall be reported as agreed upon by consensus of the majority of the board, specific to to each code provision noted in each classified employee disciplinary and corrective action form, close quote, single quote, or open single quote, letter of dismissal, close single quote. And based on the evidence and testimony presented during the hearing, I see no double quote ending, so I apologize for that. Findings will be entered into the record when summarized and presented by the board. Recommendation shall be by consensus of a majority of the board and related to the discipline imposed by the appellant's chief. The recommendation shall, I think that should be the respondent's chief. That's the recommendation shall be one of the following: affirm the decision of the chief, overrule the decision of the chief, or modify the decision of the chief as specifically recommended. No party, representative, or attorney of a party or any witness may discuss the merits of the case with any member of the board, except when the hearing of the mic is on. It's generally shown by the blue light. Tables, chairs, and the computer will be right down after each witness's testimony. There will be periodic breaks. The personnel board will convene for lunch. During breaks in the lunch period, the audio will be turned off. And we will make every effort to inform the listening audience of the duration of the breaks and lunch period. The personnel board chair will state when it is time for the board to be muted. With regard to breaks, if anyone in this room needs to take a break, please let me know. I don't want you to suffer in silence. You can take breaks tonight. I will act accordingly to as requested. The rules for video recording and live streaming that was requested by the appellant's counsel are as follows. And this has been provided to the appellant's counsel, respondent's counsel, board, and staff. I will ask counsel, first I'll start with the respondent. I'll ask Ms. Bladine, should I read this into the record, or is presenting the document sufficient for purposes of the record? I'm talking about the document entitled Minor Personnel Hearing, October 20, 21, 22, 20.
I think it's fine to attach it to the transcript and not have to read through the entire thing, but if you'd like to read through it, that's fine.
Well, it's early in the morning and my voice is already going. So unless there is an objection from counsel, I will just have that document presented into the record. I'll ask counsel for the respondent, any objection to the rules or any concerns about the rules.
Thank you, Mr. Chair. I do have one concern about the rules for the hearing. We received on Monday afternoon yesterday an order from you indicating that counsel was permitted to have 2 staff members present, a videographer and a staff assistant to help with the case. During the introductions, Mr. Zerbalik introduced this other person with him as Jim Parks. Jim Parks, and just to clarify, are you the same Jim Parks who is a member of the ASCOPS union and has a leadership role?
Yes.
Mr. Chair, in trying to figure out the equities of this situation, this hearing was ordered closed to the media. Mr. Zerbalik was permitted a staff member for presentation. Mr. Parks is not, to our knowledge, a staff member. He's a union observer. He is a participant in the underlying events of this case. And his name will come up. It is, there's an email from him that was sent to internal affairs investigators that is part of the city's exhibits in this case. And therefore, it does not seem to be that the order is being complied with. And
excuse me, Mr. Chairman, there was a thought or message out that it's difficult to hear. So if you could speak into the microphone.
Sure.
Thank you.
Is that better? Give or tell?
I'm hearing back from the right now. Yes, much better.
Okay, thank you. And so, Mr. Chair, my concern is only that if the city were permitted also to have the hearing fully open, that there are others that would have been observing and would be here, and that we object to Mr. Parks being here as not complying with your order from last night.
Mr. Sabala?
Well, I mean, the city has, if my count is right, 1, 2.
I'm sorry, please speak up.
The city has, if I'm counting correctly, at least 3 lawyers in the room, and I think that they're fortunate to have more lawyers than that and staff members that are available to assist them. My practice is relatively small, and I can avow that Mr. Park's only role here is to actually serve as my assistant today if I need to get documents or materials that are permitted. I don't have any other staff members that are available to work today, and he was already planning on being here and agreed to serve in that role. So he's not going to be taking any role in the testimony. He's not going to be doing anything except for essentially serving as an assistant. And if he were to be excluded, I can avow to you and to the vice chair that I would have then literally no one else to be able to assist me in those type of functions. So when I said that I wanted 2 people here to attend to assist, that's the 2 people that I was able to get, especially since the hearing was not ordered closed until very, very recently. So from a planning purpose, my office, I don't have other full-time staff that are available. I don't have any part-time staff that would be able to substitute in. So if Mr. Parks, who was already planning on being here and serving as my assistant, was excluded, I would face, and Commander Minor would face material prejudice. So I'm not hiding who he is or where he's from or anything like that, but I can tell you that his role is to provide me with assistant level support at this point with the appeal.
Response, counsel?
Thank you, Mr. Chair. Again, we assert the same objection, but we'll defer to whatever the board thinks is appropriate.
In the hearing yesterday before the judge, which I attended, the judge was concerned, and I think it came up in context of the media. If the media were allowed in as public media, he also said that if the public were allowed in, and the media has no greater rights than any in the public. And we're not talking about the media, but I think that the standard is the same. If a person is in here who's not a member of your staff, the question is whether they're, and he talked about the question of assistance. I don't think anyone mentioned whether or not you're a sole practitioner, really a sole practitioner. So I have to presume, just using common sense, you assume that maybe it was your secretary or you had a paralegal or something like that. Because if Mr. Parks is allowed in, that means this has become, we're going contrary to the standard, the city rule that was supported by the court yesterday. And then there'd be no basis to really exclude anyone. So I'm going to have to ask that Mr. Parks leave the room. He can go into the other room and listen to the audio, wherever the video feed is, perhaps watch that. So Mr. Parks, would you please leave the room? And understanding that, Mr. Savalik, I'm going to give you, well, I'm going to give everyone leeway if they need to take a break, confer with people who are outside the room, of course, under these circumstances, that would be necessary anyway. But we can pass you a little note, sitting in the gallery if we were in court. So I understand that. So if you need to take a break, I'm not going to say in the middle of a witness, but I think that under circumstances that would be appropriate, just not in the middle of someone answering a question. Do you understand that, Mr. Savalik? In the same place we see.
I understand your order.
Okay, so we'll proceed. The rules for the video recording have been entered.
Mr. Chairman, can I briefly be heard on the rules?
Yes, please.
So it's my understanding, and as the chair has said, that this proceeding is being held pursuant to the Arizona Open Meetings Law.
Yes.
Video recordings for Arizona Open Meetings are not restricted to specific witnesses or people testifying. For example, if someone is attending a city council meeting, they are, of course, free to record members of city council. They're free to record people that are providing testimony before city council, as long as what they're doing is not actually interrupting the proceedings. So, I mean, since we're on this particular topic, and I'm not going to belabor the point, believe me, I just need to make sure that I've made a record. It's my belief that the rules that would restrict the nature of the video recordings are excessive of what is permitted under the Open Meetings Law. I know that you provided me with a copy of the use of recordings in a courtroom. I will make a note that the Open Meetings Law does not apply to judicial proceedings, so the standards that are actually used in a courtroom and the factors that exist there are different. I'll tell you that I've been involved in a number of personnel hearings, including many that have been recorded by the media, and the only time that someone was not permitted to record a participant was when the participant, whatever their role was, basically had a sensitive position, so something like a undercover position or a position where having their identity broadcast would be detrimental to their career. So I just...
Well, I think you made your point. Response, counsel, any response?
Mr. Chair, I believe that the board has apparent authority to control the process, particularly in light of the ongoing pandemic and the accommodations that we've been trying to make. I defer to the board and to board counsel, Ms. Bleedy, on the issue.
Okay, thank you. The basis for that rule is specifically item 7 on the minor personnel hearing, October 2021, 22, 2020, was, I think, if I remember the number correct, the Supreme Court Rule 122, which you are correct, Mr. Spell, does involve court proceedings, and there are obviously different issues involved in court proceedings as opposed to the open meeting law, where people going in and out and taking proceedings. I think it may be better to, if there is an objection by the witness, that I will hear at that time. I will address it. You may talk to your witnesses, both sides, that unless there is a good and valid reason why the witness does not want to be videoed, because this is in essence a public meeting. Anyone can walk in, walk out, take a picture. You're correct, Mrs. Bell, I understand that. I'll consider the objection, but unless there's a special reason, I will probably allow the video recorder to only focus on the witness, and that is one of the specific rules, that the witness only be recorded, not anyone else. Response counsel indicated that you want to speak.
I have not spoken specifically to all of our witnesses, but I don't anticipate at this time that we will have any objection to the witness being approved.
Thank you. Can we finish with that topic?
With that topic, yes.
Next one. I also want to remind everyone that this hearing is proceeding in compliance with all relevant and applicable safety protocols. Consequently, I ask the council remain in their respective tables and not approach anyone, including any witness, unless they receive specific permission from the chair. In addition, I ask that all other persons stay in their general locations and not leave them. Further, everyone should keep their masks on at all times except for the witness. There's one witness who's been authorized to wear a face shield. I will try to keep mine on. You can take it off. We do have screens. We're all social distancing in groups. I think we're all at least 6 feet away, which is very good. So if you're speaking, please feel free to take your mask off. And I will tell you, based upon what we've done so far, may allow people in the room to hear better. So I just mentioned that. But I'm not saying you have to. I'm not saying you must not. No one is to approach within 6 feet of any board member or city staff. City staff is available to allow people to enter and exit the room and to wipe off the witness table after each witness. Please do not interfere with those activities. Council, for the appellant has requested is permitted to have staff person present. We addressed that already. However, one of those staff persons has been permitted to video record the live stream of proceedings. That person must do so in a way that does not disrupt the proceedings. All video recording and live stream devices must be turned off during any breaks in the proceeding and any executive sessions. We ask people who are here and any witnesses who may be listening to this if you're feeling sick, coughing, I'm feeling fine otherwise, shortness of breath, sore throat, or have any of these symptoms for the last 72 hours do not participate. Check on your temperature. If you're feeling warm, have it checked. If it exceeds 124, you cannot participate in person. You may wear gloves during the hearing. However, those gloves will not be provided by the city. There are, I believe, there's a sanitation station over there, and ask people up to the room to utilize that. There's a wastebasket over there, and some masks. That's all addressed. Okay. We get to call witnesses. I want any witnesses who are out of the room, and there's at least two in here now, that council have invoked the rule of exclusion. Because this rule has been invoked, the board chair orders that witnesses, other than parties or party representatives who may also be witnesses, be excluded from the hearing room. And because this is being transmitted outside the hearing room, be placed so they cannot hear other witnesses' testimony. Due to the COVID situation, witnesses other than the one testifying are not allowed in the hearing room. However, because these proceedings are being provided electronically outside the hearing room, I also order that those witnesses who may be listening or viewing to these proceedings cease doing so when witnesses are testifying. I also order the witnesses who have testified not discuss their testimony with anyone to avoid the possibility that they are speaking with another witness. Finally, because a witness may be approached by another witness, or even a non-witness, who may not be aware that you are a witness, or maybe they are aware, it is suggested, to the extent I can, I order that you not speak with anyone about your testimony or expected testimony in these proceedings, whether you've already given your testimony or whether you expect to give your testimony. This will avoid possible embarrassment of you as a witness if you're asked during your testimony if you spoke to anyone about yours or another witness's testimony. That will affect, or it can affect, the weight given to your testimony by the board. These orders will expire upon the close of taking testimony in this matter. Counsel, have I missed anything about the exclusive witnesses? Because the respondent has a burden, I will ask you first.
No, sir, thank you.
Colin, thank you.
No.
In addition, the parties have stipulated to the admission of all exhibits previously provided to the board, including the exhibits submitted yesterday. I got those yesterday afternoon. This stipulation, I want to make clear, goes to admissibility only and not to the weight that may be accorded to any particular exhibit. Counsel, did I get that right? Response, counsel?
Yes, thank you.
Yes.
Thank you. One matter with regard to appellant's exhibit is the pagination. Mr. Zabalik, if you look at your exhibit list that was provided, as I understood it, you would have the exhibit numbers and then it looks like the pages next to it.
Yes.
Correct? Just want to let you know that, this is the first one on my list here, exhibit 29 you have is in page 226. It's actually a 247. There seems to be about a 21-page difference for whatever reason. And I just alert you to that and also ask if it could be notated in the record for the city manager, if this matter is appealed to him, that the numbers may not be exactly the same as the exhibit list. And when you examine a witness on that document, use the number that's in the book, not the one on the exhibit list. I think that would be best. Mr. Zabalik, you look like you want to ask a question or say something.
I do. So, Your Honor, there was a couple different times that a lot of these witnesses were disclosed, and for the purposes of this hearing, I tried to make sure that there was consistent pagination. So if you look on the bottom left, for example, on Exhibit 29.
Okay, let me get there because I don't have tabs on.
I don't think that there's anything special about Exhibit 29. I'm just using it as an example.
exhibit. I'm on page 198, which actually looks like the middle of interview of Commander Minor. I guess if you're suggesting it's the number on the left side of the page
Yes.
is the right one?
Yes, sir.
Oh, okay.
It's the
Okay.
bottom left, and it actually says minor dash appeal dash,
Okay.
and then a number, and those are serially done for the purposes
Okay.
of this proceeding. There were some things that were not relevant that were taken out to avoid, so the record is clear. On the right side, it says COS minor, and then there's numbers. Those are not the numbers for this proceeding. It's the minor dash appeal dash number that counts as the official, essentially Bates number for this proceeding.
And I would ask city staff to perhaps put a post-it or something in the slip of the beginning of the exhibit to note that the pages are numbered on the lower left-hand side of each document. Okay, just so that's clear when it's subsequently reviewed. The other matter, well, actually two other matters. These documents came in, I know you weren't aware, but at least volume one, some of the pages were turned upside down, except for the page that indicated the exhibit number. So the city was able, in my request, the city went back and turned them around, but sometimes the exhibit identification page was also turned around. So there may be some pages upside down. And just worth noting that. So, and putting a note of that in the booklet also, so that it doesn't confuse the city manager when it gets to him. And there was one other thing. Emailed a while ago from the Balance Council were documents titled Case Summary and Executive Summary. And this is something, I guess because it could be in the technology, it was attached to Mr. Savali's email, but the document itself didn't note it was the appellant's document. So if you could notate that, you can see this back in the room where the city staff is sitting. In the record, there's a case summary, and then there's an executive summary. Just so there's no confusion when, I mean, it's obvious when you start reading it, but if someone's flipping through looking for perhaps Mr. Meyer, Commander Meyer's case summary documents, it doesn't confuse it with the city's. Continuing on, the board is in receipt of appellants and respondents' witness list, which is included in section 5 of the personnel. We're hearing minor, both Vice Chair Sutherland and I have those. I'm going to ask that Donna Brown, Human Resources Director, enter into the record the case to be heard by the board today. Ms. Brown?
Chair Guttel and Vice Chair Scoveland. The case before you this morning is the appeal of former Police Commander Aaron Minor, who was terminated on March 30th, 2020. This action was taken pursuant to the violation of Scottsdale Revised Code Section 14-72, subsections 8, 28, 30, and 35 as follows. Number 8, there are reasonable grounds to believe that the employee has knowingly made a false statement or falsified any document, report, or statement related to their employment with the city or any administrative investigation. Number 28, the employee has violated an ordinance, written policy, or administrative regulation of the city. Number 30, an employee working for the Scottsdale Police Department has violated provisions of general orders or operations orders of the police department. Number 35, the employee has knowingly and intentionally engaged in behavior which violates the city's stated values. Specifically, Mr. Minor violated Police General Orders 1411, which states, employee actions may be grounds for dismissal when the investigation properly relates to on-duty conduct or off-duty conduct that adversely affects the operation of the department and the employee fails to comply or refuses to. Number 2, answer truthfully and completely. Police General Orders 2503, which prohibits failure to accurately report all facts pertaining to an investigation or other matter of concern to the department. Failure to honestly report all facts pertaining to an investigation or other matter of concern to the department. Relating a false, deceptive, or misleading account of an incident or fact at issue in an investigation or other matter of concern to the department. Administrative Regulation 320 Ethical Standards, which states 3.3, maintain personal integrity. 3.3.1, maintain the highest standards of personal integrity, truthfulness, and fairness. And city employee values, be accountable and act with integrity, which states we are accountable for our actions and decisions. We have uncompromisingly integrity. We are responsible for stewardship of public funds and organizational resources. The more specific conduct violations of which the city terminated Mr. Minor of employment are summarized as below. On June 29, 2019, Mr. Minor was interviewed by Internal Affairs investigators as part of investigation number IA2019-048 into inappropriate comments made by Assistant Chief Richard Slavin at a May 9, 2019 meeting at which Mr. Minor was present. Mr. Minor was the first person interviewed as part of the internal investigation number 2019-048 and was asked if he knew anybody who was directly offended by Chief Slavin's comments. Mr. Minor responded, quote, I don't know specifically, unquote. When he was asked again by the IA investigator, quote, if there was someone who he knew for sure was directly offended by it and I should talk to first, unquote. Mr. Minor said, quote, yeah, not no, unquote. When Mr. Minor was asked if he had anything else to add, he said no. On July 11, 2019, Mr. Minor sent an email to Internal Affairs Sergeant Joel Lewis that stated, quote, I wanted to make sure that my statements I gave were complete, unquote, and included information about his conversation with Chief Slavin the day after the May 9th meeting. Mr. Minor asked that the email be included as part of the IA record, the interview. A subsequent interview with Mr. Minor's direct report, Lieutenant Bonnet revealed that immediately after Chief Slavin made the comments, Lieutenant Bonnet texted Minor something along the lines of, quote, what the hell, unquote, or, quote, what was that about, unquote. Lieutenant Bonnet indicated that he had detailed conversations with Minor about what occurred in the meeting while driving home that night. Lieutenant Bonnet expressed his concerns to Minor, and they discussed what Bonnet should do regarding reporting the comments. On May 14, 2019, Minor called Assistant Chief Scott Pop to tell him that both Minor and the Lieutenant Bonnet were offended by Chief Slavin's comments. Minor asked Chief Pop whether an internal investigation was going to be conducted. After IA learned of this information from Lieutenant Bonnet's interview, Minor was interviewed again and asked why when he was asked whether he knew anybody who was directly offended by Chief Slavin's comments. That Minor did not reveal that he knew Lieutenant Bonnet was offended and that he reported that to Chief Pop. In response, Minor attempted to draw a distinction between being, quote, directly offended, unquote, and simply being, quote, offended, unquote, a distinction that Minor called subtle. Minor claimed that he understood the question about whether anybody was directly offended was essentially a two-part question, whether somebody was both specifically targeted by the comments and offended in some sort of way. Minor said that he was not aware of anyone who satisfied both parts of the question and that the only person Minor was aware who was targeted by the comments was Lieutenant Myers. He did not appear to be offended. Minor also provided a written statement in the second interview. Despite claiming that Minor understood directly offended to mean both targeted by the comments and offended, Minor also claimed in his written statement that directly offended has no clear meaning to me. And the question from IA, whether anyone was directly offended, I don't know what that means. His statements and written materials presented at the pre-termination hearing further contradicted his previous claim that directly offended has no clear meaning to him. Minor's explanations were not credible. A review of the totality of the circumstances shows that Minor did not answer all questions in the IA interviews truthfully and completely. The context of the first IA interview was that Minor was the first person to be interviewed, and IA was seeking to obtain information about who may have been offended by Chief Slavin's comments so that they could interview any such persons first. Minor was well aware that Lieutenant Bonnet was offended because Minor had discussed it with him in detail, and Minor considered the fact that he was offended enough to phone Chief Pop to alert him. It is simply not credible that Minor understood IA's question about whether Minor knew anybody was directly offended to exclude Lieutenant Bonnet, who Minor knew had been offended. Minor did not ask for clarification about what the IA investigator meant by directly offended, even though Minor claimed in his written statement the phrase has no clear meaning to him. Nor did Minor inform IA that he believed the only person targeted by Chief Slavin's comments was Lieutenant Mayers, but that others had been offended. Even though Minor sent an email to Sergeant Lewis subsequent to Minor's interview indicating that Minor wanted to make sure that the statements he gave were complete, which shows that Minor was aware how important it was to provide a complete statement. Minor did not include any information regarding Lieutenant Bonnet being offended. As a former member of the command staff and having previously been assigned to internal affairs, Minor was well aware of the importance of providing truthful and complete answers. Minor failed to report to IA that Lieutenant Bonnet was offended, despite the fact that his taking offense was significant enough for Minor to report to his own supervisor. Mr. Minor's failure to reveal this information delayed the IA investigation because it wasn't until several days later that IA spoke to Lieutenant Bonnet and learned that he had been very offended. Mr. Minor's performance history during his employment with the City of Scottsdale was reviewed and taken into consideration in determining the appropriate action of the violation, including the following. Number one, your failure to timely complete or make sufficient progress on two important projects Minor was tasked with: implementing fair and impartial policing training and developing a youth initiative. Number two, the following from Mr. Minor's 2018-19 evaluation by Chief Pop states, quote, I believe you are an effective communicator, but at times your message is lost by timing. At times it appears as if you are overextended with personal and professional issues, and you are late to respond to emails, etc., and others have already weighed in. Your opinion, a message, and input matter, but if you are late to the game, you do not have the same impact as others. There have also been times when I needed items from you, and they have come in last minute or late. I believe this is an area you can improve, end quote. The detailed reasons for the dismissal are outlined in Mr. Minor's dismissal letter, which was signed by Chief of Police Alan Rodbell, Human Resources Director Donna Brown, and presented to Commander Aaron Minor on March the 30th, 2020, the effective date of the dismissal. The dismissal letter is in Section 6 of the hearing booklet. That ends my statement.
Thank you. I believe we talked about opening statements pre-hearing, but I will ask again, were council intending to make a brief opening statement, response council?
I was planning on it, yes, sir.
And response council also?
Yes, I also have to make a very brief record, if that's okay.
Each party may now make a brief opening statement of not more than 10 minutes. The respondent will proceed first, followed by appellant.
Mr. Chairman, can I make a brief objection? Generally, I won't make it again throughout the hearing because I think it can stand. Appellant, first off, I don't think that, I was listening carefully and I didn't hear it in the procedures. I think that we all agree that the Peace Officers Bill of Rights, ARS 381101, et sec, apply to this proceeding because Commander Minor is a police officer. So I'm assuming that the board is operating with that understanding of proceedings.
You have two questions. Respond to the council.
We are acknowledging that the Arizona statutes apply to the hearing. I'm not sure what the issue is though.
I just think
Well, all I heard was the question, does the Peace Officer Bill of Rights apply? And you agree, response council has agreed that they do, so they do. No, I think, let me not put words in anyone's mouth. Response council?
Okay. We do agree that the Peace Officer Bill of Rights applies to this proceeding and to the post-termination or pre-termination proceeding that Commander Minor had. One of the records that I wanted to make very quickly before we started was that the board board chair mentioned on the record that we had provided some exhibits over the weekend that were requested by the board and requested by appellant's counsel, and that pursuant to the Peace Officer Bill of Rights, Commander Minor is entitled to have those weeks before the hearing, not days before the hearing, and that the only reason that those are being considered in this hearing is that Mr. Minor is waiving any disclosure rights to those few exhibits that were late submitted.
That's agreed and stipulated.
And let me, I'm not sure there even, well, at least in one regard, I think there were general orders that I'm not sure those have to be exhibits because they public documents would take the equivalent of judicial notices that exist. The other was, if you're talking about the AR 333,
Yes.
I looked at it and I didn't realize it until I got into the dates here that the date.
Based off of the limit of access to today, like Jim Parks would otherwise be allowed in the room, for example, to provide assistance, even as a member of the public, but he was excluded based off of the city's pandemic protocol. So for the reasons that are stated in the record, that objection is here, and we believe that, despite the ruling from the judge yesterday, that the hearing not being open to members of the public to both attend and listen is a violation of the open meetings law.
Counsel, I certainly understand your position, and that's a matter that's presently before Superior Court. The whole matter is still pending. As you recall, yesterday apparently there was that judge, I don't know what the current rules of the Superior Court were, there were 2 motions in 1 document, so there has to be refiling, so the case hasn't been dismissed, so it's still there. You have appellate rights there, so.
And
your comments are taken, placed into the record. I want to thank you for that.
The last record that I'll make, and then we can definitely proceed to openings unless the city has something further, is that members of the media and members of Commander Minor's family did attempt to attend the hearing as well as Mr. Parks, and they were excluded.
And actually, counsel, it was probably a good idea to put that in the record for this hearing because, we all know it, but it's not in the record and they slip through the cracks. So it's fine to have that placed in the record. Perhaps I should have also mentioned that we had that hearing yesterday. And for purposes of whatever, unless the response counsel has an objection, well, I was going to say we could include, have that part of the record, but that I think is more than necessary. That's a different section of the attorney's office, the city attorney's office. So we'll just leave it at that. I want to thank you for at least getting that into the record so there won't be any confusion later on. So, respondent, you're prepared to make your brief opening statement?
I am.
Please proceed.
Thank you, Mr. Chairman, Mr. Vice Chairman. I'd like to start by thanking the members of the board for taking the considerable time to review many thousands of pages of documents that we've submitted in the case. I understand that it's a heavy burden to review all of the evidence, but the city has attempted to include every scrap of paper that was relevant at all to this dispute in the interest of making sure that there is full transparency and accountability regarding the discipline that was imposed on Commander Minor. This case started on May 5th, 2019. A drunk individual hijacked a golf cart and led police on a slow-speed pursuit through the city. That chase ended with the man surrendering. During the process, he was shot with a non-lethal R1 round, and he was injured by a canine that had been deployed. In the interest of accountability and transparency, the Scottsdale Police Department ordered a criminal investigation of the canine handler on the scene and an internal affairs investigation. The city has an anti-discrimination and anti-harassment policy that prohibits, among other things, disrespectful humor. Wherever a city employee violates the policy, the city's long-standing disciplinary practice is verbal counseling for the first offense, involving bad jokes or crude comments. More extensive investigations and more serious discipline has only been imposed for situations involving repeat cases or cases involving threats toward others. Following the city's long-standing practice in this case, the chief considered the matter regarding the Slavin comments to be resolved after the verbal counseling. The evidence in this hearing will show that Commander Minor was not able to accept the result of the discipline. The evidence will show that Commander Minor felt a professional rivalry toward Chief Slavin, that the rivalry began to turn personal, after Commander Minor lost out on a promotion that Assistant Chief Slavin achieved. Weeks after the Slavin matter was resolved, the police department received a request from a local police organization requesting a formal investigation into the comments. Again, in the interest of full transparency and accountability, Chief Rodbell ordered a full investigation of Assistant Chief Slavin. Internal Affairs was told to investigate the matter, and the evidence in this case will show they did so fairly and neutrally. Part of an internal affairs investigation requires that the investigators identify a target or victim of any abuse or misconduct. That's needed to show intent. It's needed to find out if the incident is part of a larger pattern or practice. And the evidence will show that internal affairs serves an important function in giving voice to victims of any potential misconduct. As part of the investigation, Internal Affairs interviewed Commander Minor regarding his knowledge of the situation, which brings us to this hearing. When Internal Affairs spoke to Commander Minor, their first witness, Commander Minor minimized the incident. He heard the comments, he described them as a bad joke, and he characterized the comments as objectively offensive, but did not indicate that he subjectively felt offended at the comments. He claimed not to know of anyone offended directly or specifically. And if we listen to the interview, we can hear that the overall tone and tenor of the interview was that it was not a big deal in Commander Minor's eyes. However, days later, Internal Affairs was surprised to discover that Commander Minor knew much more than he chose to share. They found out that he was deeply, subjectively, and personally offended by the remarks. They learned that he had been sharing information about this throughout the department, including with his supervisor, co-workers, subordinates, and direct reports discussing the incident. Internal Affairs was surprised to learn that Commander Minor had extensive discussions with the officer most personally affected by and offended by these comments. Minor's own direct reporter, Lieutenant Bonnet, was deeply upset when he heard these comments. He texted Commander Minor during the meeting to indicate his offense. He did not laugh. Following the meeting, Lieutenant Bonnet and Commander Minor spoke on the phone, discussing all the way home Lieutenant Bonnet's an offense at the comments that he heard. The evidence will also show that following that meeting, Lieutenant Bonnet will say that he was afraid. He was ashamed that others would perhaps judge him for taking offense at those comments, that he was afraid that perhaps there would be retaliation or that he would be singled out. Commander Minor was aware of his fear, and when he minimized that and concealed from IA that Lieutenant Bonnet was afraid, he delayed IA reaching out and giving Lieutenant Bonnet the assistance that he needed, the reinforcement that he needed, and delayed the process of the investigation, which is meant to give victims a voice. In concealing this information, Commander Minor crossed the line. In minimizing his own knowledge and role in events, he violated police general orders that require witnesses in internal affairs investigations to answer truthfully, completely, and that they not mislead investigators. IA investigators are not lawyers. The standards do not allow witnesses to hide behind legal word parsing if they have a reasonable understanding of what the investigators are looking for. Commander Minor knows this as a former IA investigator himself. He also knows or should know that identifying a victim is critically important to the function of internal affairs. The evidence will show that Commander Minor, before he interviewed with IA, told his supervisor that he felt that he should not have to justify offense at the comments.
I'm sorry, repeat that?
The evidence will show that before Commander Minor was interviewed by IA, he had already told his supervisor, Assistant Chief Pop, that he should not have to justify why anyone felt offended by those comments. In the end, neutral internal affairs investigators applying unbiased standards concluded that Chief Slavin had engaged in unprofessional conduct, just as they sustained unprofessional conduct against Commander Minor. Following the Slavin investigation, later on, Assistant Chief Slavin did receive a copy of the Internal Affairs investigation report and noticed the discrepancy between Commander Minor's knowledge and Commander Minor's interview transcript. He brought that attention to Commander Minor's supervisor, Assistant Chief Pop, correctly following chain of command procedures for an employee whenever an assistant chief has a concern. The evidence will show that Assistant Chief Slavin did go to Pop on occasion whenever he had a concern about Commander Minor's behavior. The evidence will also show that Assistant Chief Pop's word to Assistant Chief Slavin was final, and that if Assistant Chief Pop did not make his own independent determination, that the matter would go no farther. In this case, Assistant Chief Pop was concerned enough by what he saw that he felt he had to elevate this matter to Chief Rodbell. Chief Rodbell ordered, again, a neutral and impartial investigation into Commander Minor about this discrepancy.
Counsel, I think we're getting up towards the 10 minutes. We move along. Plus, you're almost getting into a little argument here, so let's keep on this opening statement.
The evidence will show in this case that there was no interference with internal affairs with respect to Assistant Chief Pop, with respect to Chief Rodbell, and that they fairly applied the standards applicable to Commander Minor's case. The conclusion will be based on substantial evidence that will be developed in this hearing. We will hear testimony from both IA investigators, from Assistant Chief Pop, and from Chief Rodbell himself. There were some procedural issues that witnesses will be discussing with evidence, including the fact that at Commander Minor's request and approval, before final discipline was imposed, an independent investigator reviewed and found no policy violations with respect to the Minor investigation or the Slavin investigation. And following that independent investigation into everything to do with these affairs, final discipline was imposed. This is an unfortunate circumstance. The evidence will show that unfortunately Commander Minor crossed the line, and that according to the city's discipline policies and practice, that is a hard right line. We therefore ask that you find just cause to support discipline. Thank you.
Mr. Smolik, and please keep it at 10 minutes. And again, I remind you, I have read these documents more than once, sometimes because they were duplicate, and sometimes because they kept going back to them. I'm sure I sort of got the sense from Mr. Scoglin, we haven't discussed it, we're going to go to executive session, but I believe he is the same. I think you earlier made the comment, I don't want to make sure that everything is up. We don't want to get into how they should be, but I think he said there was a lot, he said something like that there was a lot of stuff to read, so I'm presuming he also read it. So we know the facts here, so please let's move this along.
Mr. Chair, I in fact have touched and read every page twice, so.
Okay, thank you. So if you read every page twice, that means he's read some documents 3, 4, or 5 times.
Multiple times. Thank you, Mr. Chairman. The facts will show that Commander Aaron Minor reported misconduct committed by a superior officer at the Scottsdale Police Department, Assistant Chief Slavin. Commander Minor followed the commands of Administrative Regulation AR 333 that existed at the time of the meeting. AR 333 has since changed, but when the meeting in question occurred, it was clear under the policy that inappropriate statements related to sexuality were governed under Part 1 of the policy. Part 1 is the most serious aspect of the policy and should have resulted in a notification to Human Resources and a formal investigation. Commander Minor went directly to Assistant Chief Slavin and addressed the offensive comments from the command staff meeting the day before. Commander Minor told Assistant Chief Slavin that Commander Minor was shocked that those words came out of Assistant Chief Slavin's mouth. Chief Slavin told Commander Minor that he did not remember what he said in a meeting the day before, but Assistant Chief Slavin told Minor that what he learned was that he could not let his hair down in these type of meetings in the future. Commander Minor properly reported Assistant Chief Slavin's Part 1 violation to Assistant Chief Pop. Commander Minor told Chief Pop that both Commander Minor and Lieutenant Bonnet were offended by Chief Slavin's homophobic remarks. Chief Pop promptly reported this complaint to Chief Rodbell. Chief Rodbell was aware that Commander Minor brought forth concerns that both Commander Minor and Lieutenant Bonnet shared. Chief Rodbell was aware that Scottsdale includes sexual orientation and gender identity as protected classes. Chief Rodbell knew, therefore, that Minor had, appropriately, identified a violation of AR 333 and that Commander Minor had made the appropriate notification to his supervisor, Chief Pop. Despite this, Chief Rodbell did not notify Human Resources. Instead, Chief Rodbell had conversations with Chief Pop and Chief Slavin that included the fact that Commander Minor and Lieutenant Bonnet had brought forward misconduct allegations against Chief Slavin. Chief Rodbell informed Chief Pop that Chief Rodbell had, quote, handled the AR 333 violation and that nothing further would occur against Chief Slavin. Weeks later, Damian Mendoza also brought concerns to Chief Rodbell about Chief Slavin's homophobic remarks. Chief Rodbell told Mendoza that Chief Rodbell had handled the situation and that nothing further was likely to occur unless Mendoza made a written complaint. Mendoza had heard concerns from multiple members of the Scottsdale Police Department regarding Chief Slavin's inappropriate remarks, so Mendoza proceeded with bringing forward the formal complaint. Chief Rodbell then assigned the investigation to Sergeant Lewis. Chief Rodbell, despite knowing that Commander Minor and Lieutenant Bonnet had brought forward concerns related to Chief Slavin's comment, apparently didn't share that information with Sergeant Lewis. Sergeant Lewis actually first had an interview with Chief Slavin. The interview only discussed one of the two inappropriate comments that Chief Slavin had made, despite both comments being mentioned in Mendoza's complaint letter. Next, Sergeant Lewis interviewed Commander Minor. The interview was impromptu, and Sergeant Lewis did not have the outline or prepared questions that Sergeant Lewis normally used. Commander Minor answered, honestly, every question that Commander Minor was asked, but Commander Minor was not asked many questions. Commander Minor explained that the comments that Chief Slavin had made were on their face offensive. Commander Minor was told that investigators would attempt to interview everyone present when the remarks were made. Commander Minor was asked if anyone was directly offended. This phrase, directly offended, is why we're here. Commander Minor wasn't asked if he knew anyone who was offended. He wasn't asked if he had conversations with anyone else regarding Chief Slavin's comments. He was asked that directly question twice. Commander Minor's response was, specifically, no. At the end of the interview, when the tape was off, Commander Minor asked Sergeant Lewis if Sergeant Lewis wanted to go back on tape to discuss how Chief Rodbell had handled the Chief Slavin matter. After all, Commander Minor knew that Chief Rodbell already knew about Commander Minor and Lieutenant Bonnet's report of misconduct, and that Chief Rodbell did not want anything else to occur. Commander Minor was willing to go on the record to talk about these conversations, but Sergeant Lewis was not interested in this information being part of the Internal Affairs investigation. 2 workdays later, Lieutenant Bonnet was interviewed by Internal Affairs. 2 workdays later. Lieutenant Bonnet provided a written document outlining the inappropriateness of what Chief Slavin said at the meeting. Lieutenant Bonnet expressed fear that Lieutenant Bonnet would face retaliation for bringing concerns forward. A number of other members of the Scottsdale Police Department were interviewed by Sergeant Lewis regarding Chief Slavin's comments. Not a single other member of the police department was asked this directly offended question, or whether anyone else was offended. In the meantime, Scottsdale changed the AR 333. They loosened the seriousness of making inappropriate comments related to sexual orientation, and they also limited the protections that prohibit retaliation against individuals who bring forward allegations that AR 333 was violated. Chief Rodbell and Sergeant Lewis reviewed all of the interviews conducted in Chief Slavin's investigation. They did not know any misconduct by anyone else besides Chief Slavin. But Chief Slavin was aware, through conversations with Chief Pop and Chief Rodbell, that Commander Minor and Lieutenant Bonnet had made formal complaints about Chief Slavin's homophobic comments. Chief Slavin requested a copy of the investigation and transcripts, and Chief Slavin alleged that Commander Minor had willfully misled IA in Commander Minor's interview, allegedly because Commander Minor deliberately withheld from IA the fact that Lieutenant Bonnet was upset about Chief Slavin's homophobic comments. Chief Pop reviewed Chief Slavin's allegations of misconduct against Commander Minor and recommended that no investigation against Commander Minor occur. After all, Commander Minor had brought forward Chief Slavin's misconduct to Chief Pop. Commander Minor had explained to Chief Pop that both Commander Minor and Lieutenant Bonnet were upset about Chief Slavin's comments. Chief Rodbell knew this information well prior to the internal affairs interview of Commander Minor, yet Chief Rodbell pushed forward. For the first time in his career, Commander Minor was faced with an allegation that he was deliberately untruthful, that he deliberately lied or withheld information. Commander Minor was shocked. After all, it was Commander Minor who brought forward to his supervisor the violation of AR 333. Commander Minor had answered internal affairs questions truthfully. So when faced with this new allegation, Commander Minor made his record. Now that Commander Minor knew that IA decided it wanted all information as to anyone who was offended, not just those who were directly offended, Commander Minor provided written documentation of all individuals who expressed offense.
I apologize for interrupting you, but you provided a multi-page document earlier to the board. Are you basically reviewing that at this time?
No.
Because it sounds like it's all the same information, and I know we've got a number of witnesses. I'd like to move this along, so if you could also move it along, I'd appreciate it. Because I'm not hearing, you know, remember, we're not like a jury who is chosen because they know nothing. We've got 5 4-inch thick 3-ring binders, full documents that have been read. So we get a pretty good sense of what's going on. And what you're stating is more, quite frankly, in the context of an argument than a statement, which just recites the facts. So if you can move it along, I appreciate it. So we get to the witnesses.
Sure, I certainly only have a few minutes left. To put this in context, this board is asked to determine if there's just cause to discipline Commander Minor. Just cause cannot exist if the disciplinary decision to terminate Commander Minor was retaliatory. Prior to the investigation, Commander Minor had reported misconduct to his supervisor. During the IA investigation, he both answered the questions asked and offered to go back on the record to explain further context. But the investigator wasn't interested. And after Commander Minor's interview, he both extensively explained his prior understanding, as well as provided additional information related to anyone who was offended, information that I had decided to do nothing with. The actions of the Scottsdale Police Department, if they're found to be supported by just cause, spell the end of Commander Minor's job and his career. The findings are that he acted without integrity and willfully provided false information to internal affairs. This is wrong. We ask for these 3 findings from the board. 1, that just cause does not exist to discipline Commander Minor. Specifically, that Commander Minor did not intentionally lie to investigators or purposely withhold any information from the Scottsdale Police Department. 2, that Commander Minor was treated differently, that he faced retaliation for reporting conduct under AR 333 as it existed on the date in question. And 3, that Commander Minor should be reinstated to his position as a Scottsdale Police Commander.
Thank you. The respondent will now present its evidence and call witnesses in support of its charges. Any first witness available?
Mr. Chair, I believe he's waiting in the room, so give me a minute, I'll go get him.
You begin. Mr. Savard, as the court is sort of way your leg, if you move the wrong way, you may end up with,
Thank you.
I had a special mic visits here for that number and instructor.
The city's Exhibit 1, which is the complete copy of...
Yeah, just give me the number so I'll have that, I can pull them out, so I'm not shifting books out.
Exhibit 1, he has, just for reference if necessary, copies of City Exhibit 2. I'm City's Exhibit number 3, and he has a copy for reference of City Exhibit 6.3, which is his interview transcript with independent investigator Mary Crow.
6 what?
Exhibit 6.3 is just Sergeant Lewis's
I
interview.
just need the number. And that is in
City binder.
volume 1 of 2, correct?
Correct.
Mr. Chairman, just briefly for logistical purposes, and again for the record, so it's perfectly clear, on the witness stand prior to the proceeding even starting, I put an iPad there, as discussed in our pre-hearing conference, but it wasn't on the record. I just want to make it clear that the iPad in the iBooks app on the iPad has all of appellant's exhibits. So if there's something that appellant needs to reference, all they need to do on the iPad is actually just type in the page number for our
Tell me,
exhibits.
you have to tell the witness when you ask them, because if you tell me now, and he leaves, you're not gonna have to say it to the next witness. So it doesn't do much good to tell me. So just, when you need to do that, just put it on the record and tell the witness what the witness has to do.
Okay.
And the staff, I'm sure, will take care to clean the iPad after each witness.
I'm having trouble hearing. Can I remove this?
What?
May I remove this? I'm having a little trouble hearing.
Well, it doesn't appear that it's over your ear. I think the problem is Mr. Swallow has his mask on, and that's a little difficult, so perhaps you can just sort of take it off while you speak. Okay?
All right, thank you. Can you please state your full name?
Joel Lewis.
And my understanding is that Mr. Lewis is under oath, or is he going to be placed under oath?
He was.
This one.
Thank you.
I'm on top of it, counsel.
All right, thank you. Sergeant Lewis, what is your current title or role in the Scottsdale Police Department?
I'm an internal affairs investigator.
How long have you been in internal affairs?
3.5 years.
Would you mind giving us a brief background sketch of your professional training and experience?
I've been with as a police officer 19 years and 3 months. I've had training in financial crimes, solving normal patrol operating procedures, detective training, undercover training. I'm a certified fraud examiner. I've had training in internal affairs, a 40-hour course. I've been to a couple of conferences. I've been to Force Science School. I could go on.
Fair enough. When did you first join internal affairs?
April 2017.
Can you explain to the board how the internal affairs department is structured, how many investigators, what cases they handle?
Internal affairs for Scottsdale has 2 sergeants assigned to it at all times.
When you first joined internal affairs, who was your partner?
Then Sergeant Melissa Palapole.
How long did you work in internal affairs with Sergeant Palapoli?
I'm guessing about 1.5 years. She was there a little over 2 years. No, so it would be 2 years, obviously. Yeah, 2 years.
And I understand that after Lieutenant Palapoli left the internal affairs department, she was replaced with Sergeant Bolahar, who was your new partner. Is that
Correct.
right? I'd like to ask you some questions about internal affairs procedures in general, how it works. Can you describe for us how a case comes to you and what information you typically have?
Well, it really depends. It can arrive at our doorstep several different ways. It can be a phone call, it can come through the web, it can come through a letter. We still get those. It can come from a supervisor out in the field or anyone like that.
How do you go about investigating a complaint?
The first thing when it comes in like that, first thing we do is take a look at it to determine the seriousness of it. If it's something that we need to bring to an assistant chief or commander or chief right away. Sometimes there's 2 tracks that an investigation can take. One is kind of the informal track, where if it's a class 2 or 3 complaint allegation, then we can send it out to the chain of command of the officer, whoever the employee supervisor is. It's a class 1 type of complaint, then that's kind of the sole duty of internal affairs.
Could you give us some examples of what would be a class 1 versus a class 2 or 3 type of complaint?
Class 3 is automobile accident, you lost some property, you failed to attend.
Was an issue that was raised in the statements from Commander Minor's counsel and their expert witness about this witness versus target. So we wanted to have Sergeant Lewis explain those different standards so that the board would have that background.
Why don't again, and I think I talked about this in our first pre-hearing, that we have all the statements, we have all the documents, we can summarize and just say, is that what you said, or is that true, or just ask them. I don't mind if it's a leading question. If it's too leading, I'm sure Mr. Sabalik, saw him yesterday, he's a very good attorney, you're a very good attorney, someone's question is too leading, that's fine, but when you don't ask leading questions, this is going to take about 3 times as long as it's necessary.
Okay. To summarize then, Sergeant Lewis, when you provide either witnesses or subjects of investigations with knowledge of their rights before you speak with them, is it true in your experience that the subject of an investigation does not have the same affirmative duty to provide information as a witness does?
Correct.
I understand that internal affairs provides an important administrative function for the department to police itself, is that right?
That's correct.
Okay. And I've heard a phrase mentioned about internal affairs, voice for victims. Can you discuss that for me, please?
Well, part of our policy talks about trying to get to the complainant, but during investigations, not only getting to the complainant, sometimes you're talking to witnesses who are grieved and you don't know it when you get through that. So the idea is to get to the complainant. You want to try to get whoever that is, but you want to, as much as you can, talk to other parties, other possible witnesses. There are times when people are upset about what's going on, and you want to give a voice to those victims or those complainants, because it's not just, sometimes you're hearing what they told the supervisor, and so you want to hear directly from them, and most paint a vivid picture of what happened.
Is trying to find that complainant or that aggrieved person something that you do routinely as an internal affairs investigator?
Oh, yes.
Do you do that for the purpose of retaliation against that complainant or that aggrieved person?
Absolutely not.
Do you recall making a statement in your report, quote, "I thought it was important for the attendees to know," and I'm sorry, I'll back up, referring to your internal affairs investigation of Chief Slavin.
Okay.
There was a comment I read there, quote, "I thought it was important for the attendees to know that IA was looking into the allegations so that I could assuage their concerns."
That's correct.
You remember stating that?
Yes.
As an internal affairs investigator, you gather facts. Do you also make judgments or draw conclusions from those facts?
Yes, it's called a finding.
Are there any principles that guide you or experience that guides you as you reach those findings?
Well, sure, you're using the standards of policy, you're using the standards of whatever the administrative regulations are, and you're using your skill and background as a detective, as an investigator to find that. But the sole idea of getting to the truth, we're a finder of facts when we provide context for those who are going to read our report.
Counsel, again, I apologize, but you just had asked a series of questions, you talked about finding out who's the injured person. In the report, which I presume Sergeant Lewis wrote, he says, I know no one needs to be offended. So, I mean, that, quite frankly, that sort of wasted some time. The focus here has to be who said what to who. Not whether someone was offended, because under Part 1, the discrimination section, hostile work environment, harassment, it's not the person who's receiving the comment, it's the comment itself. I mean, is there any objection to that? I understand it's a matter of law. It's often described as not what the pitcher intended to throw, it's what the batter saw. And so why don't we focus on that? We know he's an investigator, he went through his training, but I think, at least it's subject to Vice Chair Spokesman's concerns about that, it seems to me the question is more, what's his experience in conducting internal investigations involving sexual harassment? Because asking someone's sexuality seems to me as sexual harassment. Reasonable people may disagree, but I think that's what we're looking at. So if you could, just review your notes in that regard. I know we've been going, it's 10:25, it's 10:25 now, we start precisely at 9, that's 85 minutes. Why don't we take a 10-minute break now? Perhaps that'll give you some time to look at your questions and see where we're going here. Okay, thank you.
Thank you.
We are